One of the more controversial parts of criminal law in Australia is the no body, no parole law. Under that law, if a convicted murderer does not reveal the location of the victim's remains, the offender could be refused parole. Parole is the conditional release of an offender, enabling them to serve a portion of their sentence in the community. The law works under the provision that the prisoner's release should be contingent on their cooperation with authorities, though in New South Wales at least it is just one of the considerations in the granting of parole. It's not an automatic refusal. In New South Wales, the no body, no parole law, or LINS law, as it's come to be known, was strengthened in October 2022 after the conviction of former Sydney schoolteacher Chris Dawson. Dawson was found guilty of murdering his 33-year-old wife Lynette, who vanished from the Northern Beaches more than 40 years ago. Her body has never been found. In March 2024, LINS law was used to deny the release of 48-year-old Kelly Lane, who had been convicted in 2010 of killing her newborn daughter Tegan on the New South Wales Northern Beaches in September 1996. Lane had been sentenced to 18 years in prison, but became eligible for parole after 13 years. She was refused parole after the authorities said it was not satisfied that the offender had cooperated to identify the location of Tegan's body. However, Lane has continually maintained that her baby Tegan had been given to her father, Andrew Norris, or Morris, soon after Lane gave birth in Auburn Hospital. Police have never located either the body of the 2-day-old baby or the man known as either Andrew Norris or Morris. New South Wales Greens MP Sue Higginson described the no body, no parole laws as being a knee-jerk response and said Lane was effectively a political prisoner as a result. In Queensland, the no body, no parole law means a parole application must be refused unless satisfied the prisoner has made a significant effort to cooperate in the identification of the body's location. In February 2024, the High Court of Australia was asked to decide whether the laws would mean that a convicted killer could be kept behind bars if it was found that they had not cooperated to locate even parts of a dismembered body. During this case, the Queensland Parole Board argued that Matthew Leslie Armitage, known as the Esky Killer, should remain behind bars because the hands and feet of the man he killed had not been located. In 2021, Armitage, his father, and another man were convicted for the manslaughter of Sean Barker, which occurred in 2013. Armitage was sentenced to 9 years in jail. Police located the burnt remains of the 33-year-old Barker near Gympie, but his hands and feet were never found. A forensic anthropologist told the court that the body parts could have been eaten by animals or destroyed in bushfires that tore through the Tulare State Forest. Eventually, Armitage was granted parole after the Queensland Court of Appeal determined the no body, no parole laws did not apply here. But the case led to a nationwide discussion on what the law means when it refers to remains. And given the law is intended to bring closure and comfort to grieving families, its advocates continue to ask, is it really fit for this purpose?